Welcome to This Week in Education Law School Administrator's Guide, episode number 24. In today's episode, I'll discuss a case about insubordination, whistleblowing, retaliation, and an administrator's hiring decision. In October 2018, Brian Shaw joined the University of Wisconsin-Oshkosh as the Director of Affirmative Action. Brian was Hmong, an ethnic group with origins in the mountainous regions of China, Vietnam, Laos, and Thailand. Brian spoke English as a second language. His job was to ensure the campus followed the university's affirmative action plan and develop policies consistent with that plan. But soon, his relationship with his supervisor, Shauna, turned sour. 2 months after Brian was hired, he drafted a race discrimination investigation report. His supervisor, Shauna, considered to be of poor quality. Another 2 months later, in February 2019, Brian gave his supervisor a 175-page self-assessment as part of his annual review. In that review, Brian claimed he was being paid less because of his race. However, his supervisor, Shauna, canceled their review meeting and declined to reschedule it, even after Brian's follow-up efforts. Brian did not get his final performance review until after he was fired. Can a supervisor refuse to reschedule a performance review meeting? It depends on the specific circumstances surrounding the cancellation and rescheduling of the review meeting. In general, an employer has the right to cancel or reschedule an employee's performance review, but they must do so in good faith and with a valid reason. In this case, it depends on how the supervisor justifies the reason why she canceled the review meeting, declined to reschedule it, and didn't provide Brian his final performance review until after he was fired. If the cancellation and the lack of rescheduling was due to discrimination based on an employee's race, then it would be illegal. However, without more information about the situation, it is difficult to determine whether or not any laws were violated. In this case, Brian did not receive his final performance review until after he was fired. This could be a violation of employment laws. In some jurisdictions, employees have the right to receive written performance reviews before termination so that they can have an opportunity to address any performance issues. This case was in Wisconsin. Under Wisconsin employment regulations, employees have the right to receive copies of their personnel records upon request, including performance reviews. According to the Wisconsin Employment Regulations, Chapter 103.13, records open to employees, the employer shall provide the employees with the opportunity to inspect the employee's personnel records within 7 working days after the employee makes a request for inspection. In this case, if Brian requested a copy of his performance review and was not provided with one, then his employer may have violated Wisconsin law. It is unclear whether Brian submitted a written request for reviewing his performance review. Back to the case. As Brian followed up with rescheduling his performance review meeting with his supervisor, Brian attempted to hire a new training and compliance officer to work under him. The search committee interviewed 3 candidates, 2 white women and 1 Latina candidate. Brian had the final say on who to hire, and he decided to offer the job to the Latina candidate because she had a law degree and she would add diversity to the HR department, which was primarily made up of white employees. But Brian's supervisor, Shauna, questioned Brian's judgment. On March 1st, 2019, Shauna emailed Brian to slow the hiring process because she had heard concerns about the Latina candidate from others who had interviewed her. 3 days later, on March 4th, an in-person meeting was held between Brian and Shauna. The recollection of what happened in the meeting varied. Brian recalled that his supervisor saying, "People of color are not a good fit for HR resources," but Shauna denied ever saying anything like that. After the meeting, Shauna requested that Brian schedule follow-up interviews with the candidates for the position. Brian responded by copying his supervisor's supervisor, James Fletcher, the Vice Chancellor of Finance and Administration. In Brian's response email, he insinuated that race was the motivating factor for his supervisor's questioning his selection of Latina candidate. In a separate email to James the next day, Brian demanded that he no longer report to Shauna. On March 6, Brian met with James to discuss the hiring situation and Brian's demand for a change in reporting structure. During the meeting, Brian alleged that his supervisor had said about people of color not being a good fit in HR, though James denied ever hearing about that specific comment. In the same meeting, Brian also raised his concerns about the HR department's hiring and promotion policies, expressing his belief that the university could face legal liability. The next day, March 7, James met with 3 other university administrators, including the chancellor and an attorney in the general counsel's office. James stated that he had decided to fire Brian subject to a review of any positive information in Shauna's written performance review. James terminated Brian on March 12th. James justified that he made the termination decision because of insubordination and poor work performance. Brian sued the university a year later, alleging race discrimination and retaliation under Title VII. I'll briefly discuss the race discrimination allegation and focus more on the retaliation allegation. As for the race discrimination allegation, the Seventh Circuit noted that Brian and his attorney made a common mistake. Brian argued that the university's justification of his termination, that is, insubordination and poor performance, was just a pretext, a false or misleading reason for firing him. But Brian failed to provide evidence explaining why it was a pretext. In the district court, Brian should have provided evidence such as he was penalized for speaking English as a second language and being stereotyped as an Asian. Let's look at the retaliation allegation. To prove retaliation under Title VII, Brian must show that he engaged in a protected activity, suffered a materially adverse employment action, and there was a causal connection between the two. In this case, both Brian and the university agree that his termination qualified as a materially adverse employment action. The crux of the matter lies in the causal connection between a collected activity and termination. The court agreed that Brian's comments to his supervisor's supervisor about discriminatory hiring and promotion practices qualified as a statutorily protected activity. Brian reported his concern to the university, and his action was considered to be whistleblowing, which referred to the act of reporting illegal, unethical, or fraudulent activities within an organization to an appropriate authority, either internally or externally. In the United States, many laws protect whistleblowers from retaliation by their employers and provide incentives for individuals who report wrongdoing, such as financial rewards and job reinstatement. In this case, the court noted that Brian's whistleblowing was protected by law. The next issue is whether the university terminated Brian in retaliation for his whistleblowing. James, the Vice Chancellor of Finance and Administration, made his firing decision just one day after Brian raised his concerns about the HR department's hiring and promotion policies, expressing his belief that the university could face legal liability. Timing matters when it comes to proving retaliation in the workplace. The Seventh Circuit reasoned that just one day between a protected activity, which is whistleblowing, and an adverse employment action could be enough to infer causation in the eyes of a jury. While there is no fixed or established rule about how close events must be to establish causation, the mere fact that the two events occurred in close temporal proximity can be a propelling piece of evidence in the retaliation case. So if you blow the whistle on illegal or unethical activity at work and you are suddenly demoted or fired, a jury may infer a causation between the two. Moreover, Title VII demands but-for causation between the protected activity and the retaliation. It means that if I can prove that my employer would not have taken the adverse action but for the fact that I engaged in the protected activity, then I have met the but-for causation requirement. It does not mean that the protected activity was the only reason for the adverse employment action. It just means that I need to show the adverse employment action would not have occurred but for the protected activity. An employer rarely, if ever, admits that an employee was fired because of retaliation. But if an employee can prove the adverse employment action would not have happened if they had not engaged in the protected activity, then the employer is in hot water. In this case, Brian argued that he was fired not just for insubordination, but also because of his complaints about his department's discriminatory hiring and promotion practices. The Seventh Circuit noted that even if Brian's demand for a change in reporting structure was ill-advised and reflect insubordination, it's a common request from a disgruntled employee. The court left it to the jury to determine whether Brian's protected activity was the but-for cause of his termination. What can educational administrators learn from this case? First, take claims of discrimination seriously and investigate them thoroughly. In this case, Brian's claims of discriminatory hiring and promotion practices were not properly addressed by his supervisor and his supervisor's supervisor. They did not investigate, but they decided to fire the whistleblower. It's important to follow the policies and the procedures for reporting and investigating these claims. Second, exercise caution when making employment decisions after protected activity. Title VII protects employees from retaliation if they file a complaint of discrimination or harassment with a government agency or human resources department, participate in an investigation into a discrimination or harassment claim, refuse to engage in discriminatory conduct or practices, request an accommodation for disability or religious belief, or testify or assist in a discrimination or harassment lawsuit. If an employer takes an adverse employment action against an employee in retaliation for engaging in one of these protected activities, the employee may have a legal claim under Title VII for retaliation. The employer cannot retaliate against employees who complain about violations of Title VII under the rules that the employee was being disloyal or insubordinate by opposing the unlawful activity. If an employee complains about discrimination and then receives a negative performance review or is not promoted, the employer could be held liable for retaliation under Title VII. To avoid this, administrators should ensure that employment decisions are based solely on job performance and not related to any protected activity. Third, in the discrimination or retaliation case, the burden of proof is on the employee to show that the adverse employment action, such as termination, demotion, or harassment, was the result of discrimination or retaliation. However, if the employee provides evidence of discrimination or retaliation, the burden of proof shifts to the employer to show that the adverse employment action was based on legitimate, non-discriminatory reasons. Fourth, foster clear communication and an open dialogue with employees. Misunderstandings and misinterpretations can lead to conflict and grievances. In this case, Brian's supervisor refused to meet with Brian for his performance review. Administrators can promote clear communication by regularly provide opportunities for feedback and suggestions and ensuring that policies and procedures are clearly communicated and understood. Remember, retaliation is not only illegal, but it undermines the trust and productivity that are essential to a healthy and positive work environment. By applying these lessons in the workplace, administrators can make informed decisions and take steps to avoid legal liability in their administrative decisions. Thanks for joining me on this episode of This Week in Education Law, School Administrator's Guide. I'll see you next time.